Hello friends, in the series on the income tax cases, today we will discuss a very important judgment of Commissioner of Income Tax versus PRAKASH LUNIA. This case has been decided by Supreme Court and the case has been reported in 454 ITR at page number 61. The date of the judgment is 24th April 2023. In this case, the assessee was dealing in silver. The assessee was also smuggling silver from outside the country, due to which there was a search by the DRI department on the assessee, and in that search 144 slabs of silver were found which were held by the assessee illegally and by smuggling it. The DRI department seized this silver and accordingly intimated about this to the income tax department. The income tax department also came into the action. The assessment was framed under section 69A, which talks about unexplained money of near about 3 crore rupees. During the assessment proceedings, it was the plea of the assessee that the silver which has been seized by the DRI department is a loss to the assessee and it should be allowed in computing the addition made by the income tax department. But the assessing officer was not convinced with the assessee and accordingly made the full addition of the value of the silver, that is near about 3 crore rupees. The assessee went to the CIT appeal. CIT appeal dismissed the appeal of the assessee and ITAT also dismissed the appeal of the assessee. The assessee moved to the High Court. The High Court, relying on the judgment of CIT versus Piara Singh 1980, which was decided by the Supreme Court and which was reported in 124 ITR at page number 40, gave relief to the assessee, meaning hereby that the High Court was of the view that whatever the silver has been seized by the custom authorities through the raid by the DRI department should be allowed as a business loss or expense to the assessee. The department preferred appeal before the Supreme Court against the order of the High Court, and the Supreme Court dismissed the contention of the assessee and allowed the appeal of the department and said that in this case the assessee was doing the business of silver. There was no doubt about it, but at the same time, in order to generate more profits, the assessee involved into an illegal business or in a business which is prohibited by the law of smuggling silver. So if any loss is incurred by the assessee due to the seizure of the silver by the DRI department through custom department, then it will be termed that this loss is due to an act which is illegal, which is prohibited by law, or which is an infraction of the law, and that loss cannot be allowed to the assessee. And according to the Supreme Court, that is the intention of the legislature by the explanation to the section 37 subsection 1. So the decision given by the High Court was reversed by the Supreme Court and the judgment was given in favor of the department by laying down that the seizure of any silver which is smuggled outside the country or which is smuggled from outside the country, that cannot be allowed as a business expense or as a business loss if the addition is made under section 69A, that is for unexplained money. Friends, this case is very important as far as all those seizures of illegally smuggled items are concerned, because now it is a clear law that loss due to the seizure of illegally smuggled items cannot be treated as an expense or loss under section 37 subsection 1. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax versus PRAKASH Chand LUNIA, and this case has been reported in 454 ITR at page number 61. The matter has been decided by Supreme Court. The date of the judgment is 24th April 2023. Thank you, friends.